In this Texas courtroom, multiple defendants face serious felony charges. Some enter guilty pleas, others negotiate probation. The judge explains the impact of prior convictions, fines, and potential prison time. Understanding the law can literally change your outcome.
Judge, on this one, if we may proceed on the full indictment, I think we need that to get to the third.
Good morning. Are you Tristan Jones?
Yes, ma'am.
Mr. Parker, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Hold on, I've got too many things. Right, Mr. Jones, in clause number 25, GCCR 1668, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from September 30th of 2025. The indictment alleges you were previously convicted of evading arrest or detention October 18th of 2024, and then after that was final September 25th of 2025. And then the indictment further alleges that you were previously convicted of possession of methamphetamine, state jail felony, February 8th of 2018. And after that was final, you were convicted of unauthorized use of a vehicle, a state jail felony, February 26th of 2025. And how do you plead to that charge? So to the original charge of evading arrest or detention from September 30th of last year, are you guilty or not guilty?
I'm not guilty.
Okay, so why did you do paperwork for a plea of guilty?
Oh, I didn't. I thought I didn't know you were adding all that together since 2018.
That's the stuff that we talked about, how you get to where you're a third degree felony. I explained it to you when we were in there.
I used all of that. A lot.
It is a lot.
I've explained the same at length, Judge.
So those prior offenses make it to where your punishment could be a third degree felony, which is between 2 years and up to 10 years. So the first two, the evadings, make it a state jail.
Yes,
So you've got a misdemeanor that is enhanced to a state jail because you've got more evadings. Then you've got more state jails from prior, which makes it then a third degree felony. Do you understand?
Yes, ma'am.
And that's what Mr. Parker went over with you?
Yes, ma'am.
Okay. So to the offense of evading arrest or detention with previous convictions, are you guilty or not guilty?
Yes, ma'am.
Guilty or not guilty?
Guilty.
To the prior offenses of evading arrest or detention, are those true or not true? Is it true or not true that you were previously convicted of evading arrest or detention in 2 prior cases?
True.
And then is it true or not true that you committed the state jail felony offense of possession of methamphetamine in February of 2018? And then after that was final, you were convicted of unauthorized use of a vehicle of state jail in February of 2025. Are those true?
Yes, ma'am.
True or not true?
True.
So did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
So you can't change your mind later if I go along with this agreement. You understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objections?
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that your a plea of guilty freely and voluntarily, and also your pleas of true. Find that you're mentally competent and understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with prior convictions. Find those prior convictions true in the indictment. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows these were agreements, or this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yep.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. A firearm is a legal term. You should read that admonishment to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker.
What's wrong?
So the court is aware, but he did just probably county jail time on most of those misdemeanors out of Harris County. He has done one lesser TDC amount, but he's never done as much as the four. That was.
Okay.
And your honor, just out for procedural measures, he has a case out of Orange County. I'm not sure if they have a hold on him, but he thinks there may have been a PR bond set. I'm not sure, but I was hoping that there's somehow we could check and so he doesn't go to TDC and then we can get him fit for Orange. I don't know if it's nothing to do. Okay.
Yeah, I'm not.
I just thought I'd bring
The
your-
jail,
okay.
I mean, if there's a hold from another county, maybe the best thing to do would be call Orange County to
Okay.
let them know that we're done. And
I'll
they
do
might, if they can come get them somehow, but if,
I'll do that, Judge.
that would probably be the best route, because if they don't have a hold on them, then our jail's not gonna see it and,
Okay.
and do anything with it.
Thank you,
You
Judge.
can go back with the bailiff. Thank you.
I already called that other.
Yeah, we already took care of that. Good morning, sir. You're Tristan Calhoun.
Yes.
And Mr. Calhoun was previously in court, entered pleas of guilty in cause numbers 25 DCCR 1216 and 1217. I've received the pre-sentence report, as well as it looks like 2 memos from probation that were follow-ups to that report. Have you all had an opportunity to review all of that?
Yes, Your Honor.
Are there any additions or corrections to that pre-sentence report?
The only correction we had was under the substance abuse history. I believe they, their alcohol data first usage, it should have been 18, 19 years old, not 8 or 9 years old.
Oh, okay.
Yes, ma'am, but that was the only correction.
Okay. Thank you. Anything?
Judge, I would just like the record to reflect that my office made multiple attempts via a regular victim contact letter with both of the complainants in these cases in order to try to obtain a restitution amount via that letter, via a restitution request form. I then was able to work with Miss Roach, who did some investigation on it. And we have an investigator to find different numbers for those young ladies. They were able to reach out to them and have them call to the probation department. As of this time, unless it's somewhere in the paper sphere, I don't have a restitution amount from them. I understand their concerns that they voiced, but I believe that the offer was appropriate based upon his lack of criminal history and the severity with which the court can punish him on any type of revocation. I don't know how Your Honor would feel about ISF based on his age, but I would suggest maybe at least considering the positive track of ISF.
And Your Honor, I have spoken with Mr. Calhoun in regards, I told him there could be restitution in the future if anything is provided.
Well, if it's not ordered today, there will not be any. And
Okay.
So that's why they attempt
Mhm.
to get all that information. And it sounds like the district attorney's office and the probation office has made a diligent attempt to try to get any number. And so there's no coming back later for restitution. So we'll just have to go forward without that. Mr. Calhoun, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. And in cause number 25, DCCR 1216, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 7 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'll go over some of those in just a few minutes. And then in cause number 25, DCCR 1217, also find sufficient evidence to find you guilty. However, I'm going to follow that agreement and defer all proceedings and place you on probation for 7 years. You'll be ordered to pay a $500 fine in that case as well and to follow all of the rules and conditions of probation. I am going to order that you enter and successfully complete the JCDI program. It's an outpatient treatment program. That's what was recommended after that substance abuse assessment was done. I'm not going to order any further upfront or ISF. I think you're 28 or 29.
28.
Okay. This seems very, very out of character for you. And this was a terrible day, and what you did was terrible and affects at least one of these ladies had some significant issues and probably will forever based on this. But I mean, you have no criminal history, and so we're going to get you the help you need, and hopefully you can be successful on probation and not have any issues. So what that means is you don't have felony convictions on your record right now. And if you successfully complete these probations at the end, the case will be dismissed, both of them. You'll never have a felony conviction. So it's a great opportunity that you're getting today.
Yes.
The other side of that, and part of what Ms. Molfino was stating, is that if you violate any condition of your probation, you can be brought back into court. And then I could find you guilty of both of the offenses and sentence you to prison for between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
So I'm handing you in each of your cases, the trial court certifications that shows these were agreements that I followed. And so you have waived your right to appeal. Probation will talk to you before you leave the courtroom today. It's very important that the first thing you do when you are released is go to the probation office and make sure you get everything started and lined up with them.
Yes, ma'am.
All right. Yes, ma'am.
Sorry, just if I may, so the
Shady.
record reflects and in the instance that anybody is observing. Of course, I would not hesitate at all to put those victims in contact with victims assistance for on victims compensation.
Yeah.
Based on these pleas, I think that would be an avenue that we can travel down, and that I don't want this to obstruct that, but I understand the restitution amount. I did not have some for today.
Sure. And there are definitely some avenues, if they get in touch with the district attorney's office, that might could help them with some of that. Okay. Thank you, Ms. Malfino. You can go back with the bailiff.
Thank you.
Yes.
Thank you.
All right. Careful.
Again, and then go make trial document.
Okay.
And I don't think anything's changed about the offer either.
Okay.
You agree?
Great, Pam.
Right, it's the same offer, 30-year cap.
It looks like previously
It may have been,
to reduce the charge or to
No, that's what they were requesting. That I do.
That was our counter.
not. Anyway, okay, can't read it.
My handwriting, I suspect.
All right, you're Ava Musgrove? Yes, Sharon. And in clause number 25, DCCR 0048, Ms. Musgrove is charged with the first degree felony offense of murder. And that's from December 29th of 2024. And what that means, ma'am, and we've gone over this before, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand? Yes, Sharon. And I have a plea bargain rejection that you've signed here today with Mr. Gertz that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 30 years in prison, which means you would be leaving your punishment up to me. I could give you 30 years. I could give you less. It would depend on any information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand possible consequences if we go to trial and what your options are. And do you understand all of that? Yes, Sharon. And do you want to reject that offer and have your case set for trial? Yes, Sharon. All right. And so based on kind of some of this back and forth, is there any reason to believe anything would change with regard to that offer?
There we go.
So I want to make everyone, make sure everybody's clear that there will not be a plea. This plea agreement will not be accepted after today. So it's either trial or a plea to something different unless there's some new evidence that's discovered that you guys don't have for some reason at this point. Do you understand? Yes, sure. All right. And as far as you know, you have all the discovery and.
As far as I know.
Okay,
of all the stuff,
you're
yes.
not waiting on anything?
Not, I don't know if anything's still out there.
Okay, we'll get it set on the next available trial docket. You can go back with the bailiff. Okay. Good morning. Are you Marco Gomez? Speak up, please. And this is clause number 21-36534. And Mr. Gomez is charged with sexual assault, set for trial to begin with jury selection on Monday, the 23rd. And what is the announcement?
Great. Stay true.
All right, obviously, this is one of the oldest ones we've got, and so I would anticipate that it would be pretty high on the list, if not the top. Is there anything that you guys need me to know or we need to discuss before I number those cases today?
No.
All right, it looks like there was a previous rejection back in November. No changes or to that. That was for 15 years.
That was the offer we rejected, Judge. We had actually signed paperwork this morning for 8. After we signed it, I think the complaining witness called Mr. Smith and expressed that she did not want the 8-year offer. And so that was withdrawn. So
Okay.
we're here back at the trial docket.
All right, so then I'll set it. There won't be any plea agreements after today. Mr. Gomez, if you change your mind and want to enter a plea of guilty, it would be open to the court or to some other number other than that 15. Is that where y'all are at 15?
That's where we're at, Judge.
Okay, all right, then I'll set it and we'll probably see y'all at 1 o'clock on the 23rd. You can go back with the bailiff.
Judge, I have Willie Pew.
Yeah.
Just need a reset on that. He's looking to hire in his own term.
Let's get Mr. Pew, Willie Pew. All right, are you Willie Pew?
Yes, ma'am.
And this is 25 DCCR 1835. Mr. Pew's charged with unlawful possession of a firearm by felon. Mr. Pew, Mr. Rojas has let me know that you or your family are trying to hire a lawyer. Is that correct?
Yes.
So are you asking me to reset your case a little bit to let y'all do that?
Yes.
So what I'm going to do is about a 30-day reset, which is a normal reset. If y'all get someone hired, they'll do the paperwork to substitute in. If for some reason you're unable to hire someone, Mr. Rojas is still your attorney, will remain on your case. And when we come back at that 30 days, if you haven't been able to get one, then we'll need to move forward with Mr. Rojas, okay?
Yes, ma'am.
All right, you can go back with the bailiff. Thank you, Mr. Rojas.
Thank you.
You've got Brian Trejo.
We've already taken
We
care
already
of it.
did that.
Unless you want to reconsider.
Nope, I'm good. Thanks. Forgot. Good morning. You're Giovanni Coleman. And this is 25 DCCR 0479. Mr. Coleman's charged with murder. Mr. Gertz, what is the announcement?
Judge, we're gonna ask for one additional resetting. There's a number of reports and videos in this case that involves, I would say, pretty hyper-technical cell phone and block evidence. So block evidence is photographic evidence. Okay, sorry.
Thank you.
Sorry. Is this your first day?
It's not
my first day.
It's not my first day, but I appreciate that.
I apologize.
That's okay.
I'm so sorry. Either way, that a lot of the mapping and location and work that was done here just needs some additional review, in my opinion. And so, and then we were able to find very recently a ballistics report that was not labeled ballistics report. It was labeled like F-25 and didn't have any content. And so anyway.
So I'm gonna do one more. It looks like you have been on since May 2nd. So it's getting time for an announcement. I'll do another reset, but we need to see if we can get an announcement at that next court date.
Okay.
Okay.
Good. Thank you, Judge.
Stay in touch. He'll stay in touch with you.
She'll tell me.
See, you've got me thrown off
Yeah.
now.
Wait
Ronald
till this next hits.
Spites.
I need a couple minutes on that, Judge.
Okay.
I'm gonna be asking for more time on that. So if you want to call him out.
I can get it done if that's what you.
I can do that. I just need to talk to him too. So.
Spites. We can ask him to keep them for a second after. It's me. Good morning, sir. You're Ronald Spikes.
Yes, ma'am.
This is 25 DCCR 0920. Mr. Spites is charged with manslaughter, and Mr. Gertz, what's the announcement?
Judge, we're asking the court for one additional resetting on this. I need to sit down with him and just haven't had a chance to talk in detail enough about the allegations here and the evidence that they have provided us, which I believe have downloaded everything that has been uploaded. So.
Okay. Anything that you know of that you're waiting on? All right, so Mr. Spites, what I'm going to do is now that Mr. Gertz has everything, he'll be out there, I'm sure, to go over all of the information and discovery that he's received, and then we'll see where we are at the next court date. Okay, thank you. Ms. Holmes?
Yes.
You got Tristan Calhoun, the Senate. And Mr. Ruiz, you were here earlier and sworn in, correct?
See,
Okay, thank you. You may proceed.
Thank you, Your Honor. Would you please state your full name for the court reporter?
Sereno Lopez.
Sereno Nabor Lopez Reese.
And if I can get you to speak up, I want to make sure that you can be heard.
Sereno Nabor Lopez Ruiz.
And what city do you reside in?
Port Arthur.
And what do you do for a living?
I'm a fisherman.
All right. And back on June the 18th of 2023, were you at
Sentences are handed down according to agreements, prior convictions, and severity of the crime. Some defendants receive probation with strict conditions, fines, and mandatory programs. Courtrooms ensure accountability while providing avenues for rehabilitation, and failure to comply carries serious consequences.